Hey everyone, Attorney John Waite here, here to bring you another batch of forms changes from NC Realtors. I'm recording this in late January of 2025, and so what we got here are several important forms updates that you guys need to know about that have just been released. A lot of these are settlement related, and some of them are just cleanup, just trying to make sure things are I'll just back up a little bit and explain it this way. When the new rules were announced last year, like early last year, obviously the forms were built for a completely different system, okay? And so while we did some changes last year to bring the forms into a kind of, okay, this will work compliance, okay? This year, the Forms Committee has been very focused on trying to make sure that we take the next steps to make sure that the forms go above and beyond as far as the new system is concerned. So while I know it feels like a lot, and I know what we're going to talk about today is going to be a heavy lift for some of you, hopefully as I go through you'll be able to see that as far as the new environment you guys are operating in, these forms changes will help you work better in that environment. So that's really what these forms changes are about. So what do we have on the docket for today? We have a completely rewritten exclusive right to sell listing agreement. So that's what's on the screen right now. And we'll go through that, do a couple of back and forth between the old form and the new form, kind of give you some important updates between the two, okay? Then we also have a new, just a couple small edits to the exclusive right to sell, the exclusive buyer agency agreement. If you recall, that was rewritten in October last year. A couple small edits to that. And then we have a small edit to the property showing agreement, which is Form 202. And then finally, we have a new non-exclusive buyer agency agreement, a rewritten non-exclusive buyer agency agreement. That is Form 203, okay? So we're gonna go through those in that order. And let's go ahead and just jump right in with the exclusive right to sell listing agreement that's here on your screen. So one of the big differences you can see in the new form, much like the new exclusive buyer agency agreement, is number one, you can see over here, this is 7 pages. In the old form, it was 13. So the form has been cut down by 6 pages. And it's not meant to sacrifice the way the form operates or functions or anything like that. Rather, this is just one example that I'll just start with on the first page here. You can see, you have seller firm, services provided, term of agreement, property, and then the fixtures. This is all on the first page, okay? But on the old form, you start off with a lot of this language at the top. What if the seller is a deceased person or a corporation or a non-owner spouse, all these other issues. A lot of these things that are in these notes and that were otherwise in the old form have either been moved to the guidelines, which there will be interim guidelines available for all of these forms changes in the legal Q&A section of the ncrealtors.org website. So if you have any questions or follow-ups, you can check there. There will also be materials there in addition to this video, okay? So a lot of that stuff has been moved to the guidelines if it didn't need to be in there, or in the case of a deceased owner, we have a whole form for that, Form 10-T, and that is a flow chart that's meant to help you navigate, all right, who needs to sign when there's an estate involved. That is a joint form with the Joint Forms Task Force, so you've got attorneys from the real property section giving input on that flow chart. That is a much better resource for you than having this language that's here on the screen taking up a lot of room on the first page. So on the first page, you barely get, the property description is split between the first page and the second page, whereas in the new form, to move those things off to a more appropriate spot, and then make sure you can put property in here. All right, as far as changes in the new form that you might want to note, here you have a checkbox for additional parcels. We still have a couple meetings left of the Forms Committee, and I'm hoping that we'll be able to put an additional parcels checkbox in the offer to purchase and contract as well. So hopefully that'll get in there. Here we have fixtures all on one page, and then on the next page you'll talk to your seller client about unpairing and deleting data. Make sure they know about that. Items leased not owned. This is very similar to the old form, so I'm not going to go into a lot of details on that, other than to note that I've been getting plenty of phone calls on the hotline about solar panels. For whatever reason, sellers really just don't want to pay the lien off on the solar panels. Maybe that's just because of the amount or whatever. I don't know the reason why. Generally speaking, in the offer to purchase a contract, any fixture on the property that has a lien on it, the seller is obligated to pay that lien off and then convey it to the buyer, unless the parties otherwise agree. So what I'll say about that, when it comes to solar panels, or like a new HVAC system, any sort of big system change to the property that still has a fixture lien on it, make sure that you're having a detailed conversation with your seller client about, all right, well, you're either going to pay this thing off and convey it, so build that into the price, or if your seller client doesn't really want to do that, you got a competitive market, whatever the case may be, then you're going to want to consider doing some kind of addendum, a custom addendum, to make sure you talk about the assumption of that lien when it comes to the offer to purchase a contract. But you're also going to talk about it in the listing agreement here, okay? So make sure you're doing that, having that conversation. Personal property, there's still the personal property lines in the offer to purchase a contract. Sometimes it's easy to put things in there, but please do not forget Form 320-T, which is the agreement and bill of sale of personal property. You can use that if, for example, the bank doesn't want you to have certain kinds of personal property in the offer to purchase a contract. So just remember that form is there in case you need to use it. All right. Moving down, we have in paragraph 5 here, we have the listing price of the property. Again, this is substantially similar to the old form. And then we come down to the marketing section. Again, this is also substantially similar. It's been condensed a little bit, but otherwise it works the same. So you're going to put in marketing date at the top. If it's going to, if it's the effective date, just put in the effective date. Like whatever date you're signing this thing, that's the date you put in there. I just had a conversation with somebody the other day, so I'll just go ahead and mention it, while I'm here in this section. Office exclusive is marketing. So if you're going to be, marketing a property inside your office, even though it's, exclusive to your office, it's still something that is still marketing the property. So that's going to be the marketing date that's up here in the top. So this part right here, okay? So just make sure you understand that and make sure that when you're filling in that data, that's what it is. And then later, if you're going to switch to public marketing, there's a couple different ways you can put that in there. One, you could put it down here because we have these lines just like the current form where you can put in additional terms. So down here in paragraph 19, that is still going to, that's in the old form and it's also in the new form. So, you can put that in there, or you can use Form 710 and just amend this listing agreement so that you're moving over to public marketing. You can put this stuff in there that needs to go in there. All right. Moving down, lock boxes, this marketing risks. The marketing risks paragraph is probably, at least for some sellers, you're going to want to cover in some detail. You just can't guarantee everything about a particular listing and certain things about the property while people are going in and out. So make sure that you cover that with them and that they know what's going on with that. All right. Another warning here about surveillance devices. That can be a pretty important one, so make sure you talk about that. But also we cover it a little bit further in section 16, which is referenced here. Okay. This section here is the fee for the firm services. This is going to be a substantial deviation. So if you've been tuning me out to this point, it might be a good time to pay attention. All right. So first at the top here, we have this negotiable fee language, which is language that's required by the settlement. Okay. Paragraph B, we have firm's fee. This is only your fee. This is what you are working for as the listing firm. This is what you and the seller are agreeing. This is going to be what you are going to be paid. Okay. So that's paragraph B. This is a substantial change from the old form. In the old form, over here, paragraph 7, you have the firm's compensation, right? So that was paragraph 7 here, and then it goes through earned, due, payable, all this stuff, right? And then in paragraph 8, you'd basically do kind of a subtraction of, all right, well, of that amount that's in section 7, what are we going to potentially offer to other agents as cooperative compensation? The reason it was set up that way is because that was substantially how the MLS, operated at that time. And that is not the case anymore. There's a lot more, at least depending on how firms, go about offering cooperative compensation, if any, or if they just have the sellers do it or whatever. Cooperative compensation is simply a separate topic. And so the new exclusive right to sell listing agreement does the same thing. All right. So we got what you're working for in subsection B here, all right, of paragraph 7. And then in subparagraph C, all right, what are you going to potentially offer to other agents? Now we go through some check boxes here. One, the seller either does or does not agree to offer cooperative compensation. So that's right here in the top. So you're going to check those boxes and figure out whether the seller does or does not agree to offer cooperative compensation as a threshold question, right? Then we move on to these check boxes. So number 1, the firm is authorized to offer a certain amount, okay? Number 2, the seller may offer a certain amount. Why the difference in the two? Because if this is a situation where if you have a firm policy where the firm itself does not offer cooperative compensation, then your seller, if your seller is going to do it directly, then you want that authorization as the listing firm to say, all right, seller, you want us to advertise that you're offering a certain amount. All right, well then, this is the writing that says this is how much it's going to be. All right. And then third checkbox is if you want, you can do an attached policy that's different from one of those two options. Okay. So if the seller authorizes the firm to offer cooperative compensation, then basically the way this language works here is that the firm is going to advertise it, however they want to, however the sellers authorize them to advertise it up to a certain amount, right? And then the negotiated cooperative compensation is to be paid by the seller to the firm at closing. Okay, so this is this little, you can see this little B right here, all right? And then in C, then it's going to be dispersed to the cooperating agent by the firm. So it'll be part of closing. It'll be facilitated by the closing attorney, but it explains how the money moves. Okay, but it's not being deducted from firm's fee up here. Okay. So just be careful how you fill this out. Make sure that you're specifying your fee and then an additional, whatever's additional down here that may be offered as cooperative compensation. And I've said this before, it's true under the old form, it's true under the new form. And buyer agents, make sure you're listening to this because I get calls still kind of on the regular with buyer agents thinking that, well, if you've authorized this word here, if the firm is authorized to offer a certain amount, but they don't offer me that as the buyer agent, is there anything wrong with that? No. The firm is authorized. They're not mandated to offer a certain amount. The cooperative compensation is negotiable, and it must be, okay? So, no, you don't need to see the listing agreement. It's not something you're going to file a complaint about or anything like that. What the seller and the listing agent decide to do is what they decide to do. They're going to choose to negotiate cooperative compensation however they choose. And that may be they're going to offer a certain amount and the same to everybody, and it doesn't matter on the offer. Other firms, they may well, the amount of cooperative compensation they're willing to offer you may depend on the buyer's offer in the purchase contract. All of that is permissible. All of that means it's negotiable. That is the new landscape that we are in, and thus why the firm's fee here in subparagraph B is broken apart and made separate from the cooperative compensation here in C. All right. So if the seller offers cooperative compensation directly, we have here in this little Romanet 2, just seller agrees to pay it, and if they don't, they're going to be in breach. And then I would venture to say if you got a seller who's agreed to pay cooperative compensation directly, either with 220 or some other form, whatever, and they choose not to do that, this little Romanet 2 is going to, that means it'll be a material breach by the seller. So just make sure the seller understands that, if they're going to offer that, you've put it out there, right? You've been given up here in this second checkbox authorization to offer a certain amount. It gets negotiated, it gets written down in Form 220, then, or whatever form you're using. Then that means that they need to do that, or obviously it's going to cause major headaches in the transaction. All right. And then finally, Romanet 3 is just a reminder that if the seller doesn't have to do it now, even if they up here say they do not agree to offer cooperative compensation, they could do it later, and that's fine. Just make sure that as the listing agent, some kind of writing or email, some kind of authorization from your client saying, hey, offer this now. Like we've tried it a certain way, a certain number of days on market or whatever. let's go ahead and move on to something else. All right. So then in subparagraph D, we have the total cost. This is a new line. This is new from the old form. And it's here because these two things are now broken apart, firm's fee and cooperative compensation. So you're going to want to make sure the seller has whatever that total cost is and go ahead and put that here on this line. Okay? Make sure that if your listing firm charges a transaction fee or something like that in addition to whatever you as the listing agent might get, make sure you're putting that up here in other fees. Make sure that the total amount, remember this agreement, and it's true with the old form and it's going to be true with this new version, okay? The agency is with the firm, so that means that the firm's fee, the listing agent, whatever they are getting as part of their work, that is all collectively together part of the firm's fee. So make sure you're just putting it all up here in subsection B. And then here we have earned and due and payable. That is substantially similar to the old form. I'm not going to get too far into that. Protection period is still here. It still works the same way. The only thing I'll bring up about that is that a lot of agents were surprised when the rewrite came out of the exclusive buyer agency agreement in October, that the protection period gets cut off if the client signs with another firm. That's still the case here. So just understand that language is there. You can put the protection period in. It's meant to protect you, where if you're working with a client and you introduce them to a property, they can't just wait for your agency agreement to end and then go work with the seller directly. It is meant to protect against those sorts of abuses, not to prevent a former client from going and hiring another firm if they want to. Okay, and it's a difficult. I understand there's not one right way to go about this, and to try to be fair to the client, fair to the firm, and everything else. But in any event, these forms have been this way for a very long time, and so to the extent that they might be changed, that would be up to the purview of the forms committee and the executive committee, not me. So in any event, just know that language is there, and know that that's part of the old form and part of the new form. So if you got any agency listing agreements on the old form, that's true as well. All right. Home warranty, we got that here. That's in the old form too. Substantially similar language for a pre-marketing home inspection. Here we got a little change from the old form that you might want to note. This section is in the old form, but there used to be default language that if the buyer defaults on a purchase contract, I'm talking about little subsection B here, then the seller automatically agreed. The default language was that the seller and the listing firm would split any potential earnest money deposit forfeited by the buyer. Here, now it's made optional with some check boxes. Because honestly, most of the time, whenever listing firms will call me about this on the hotline, they didn't want to do it. They wanted to waive it anyway. So it's something where if that's your firm's position, obviously the seller's going to be excited about that. But depending on the transaction, it's really not fair for the listing firm to have to give that up. You guys, as I've said before many times, you take on such a risk with taking these properties on contingency. You put up costs and things like that. So that's a discussion you want to have with your seller in detail about what you're doing and the kind of risk that you're taking, and able to do that. And honestly, it's a conversation that you also need to have if you end up terminating agency. And we'll talk a little bit more about that later, but if you use Form 720, there's a line on there when you're terminating agency about the costs that the seller will reimburse you. Or in the case of a buyer, it's the same thing because it's the same form that you would use. But it's a conversation you want to have with your client about what you've done. Now, granted, trust me, I get the phone calls about difficult clients where it doesn't matter, they're not going to listen. Okay, fine. But hopefully you get reasonable clients who can understand a little bit better. All right, so I'm going to move my thing down here just a little bit. Let's see if I can, because I want all this dual agency on one part here. All right, there we go. So here we have a dual agency section that is substantially similar to the dual agency section that came out in Form 201 last year. There's been some changes to it though. If you look at compare to the old Form 201 to this here, Hopefully this flows even a little bit better than the other one. The hope with the exclusive buyer agency agreement last October was that this dual agency section would cut down on confusion and cut down on agents filling it out wrong, which a lot of agents were. Okay, and I think we got closer in October, and I think we're taking yet another step closer in this iteration here. Shout out to the forums committee on this one. They did a really good job of giving input to me and just how you guys are out there practicing, especially in the dual agency context, and really helping inform about how it could flow even a little bit better than what we did in October. So let's talk about it a little bit. So this top part here, like all this stuff in here, this is substantially the same. So let's go to these authorization lines right here, okay? So we've added 2 lines, but I'm just gonna go through these, instead of talking too much about how the old initials worked. There's actually a Q&A on it that will probably retire once these come out, because it won't be applicable anymore, or maybe we'll just update it. I don't know, I haven't decided yet, but in any event. So now you have 2 lines right here at the beginning of the authorizations where the firm either may or may not act as a dual agent. So you're just gonna do one of these lines, okay? So that's simple. We're either doing dual agency or we're not, all right? Then in the next 3 lines, instead of the next 2 lines, there was 2 lines before, so now there's 3. So either A, the seller does not authorize the same agent to represent both, okay? B, they do. Or third option is seller is not going to authorize the same agent. I mean, by definition, because designated dual agency requires 2 different agents, okay? So seller directs firm to practice designated dual agency. If seller directs firm to practice designated dual agency, then firm will do it unless it's not allowed under North Carolina law and seller authorizes something else in writing later. That last part, the little Romanet 2, was in the old form, but it was not in Form 201 that came out in October. Mostly because as part of that change, trying to really clarify the agency relationships between the clients. But there was plenty of feedback saying, hey, this is a lot more in flux. We could do it with getting direction in writing from our clients. So let's put that back in. So there you go. It is back in there. You can see that the flow of this is probably closer to the original, honestly, but it's hopefully simpler and a little bit more condensed, so that you're just choosing between the first 2, choosing one of the next 3. That should get you covered one way or another. If any of that changes, you can either amend your this agency agreement with Form 710, or you can go ahead and make an update on the form. All right, or get some kind of writing email that makes it clear what you're doing. Okay. All right, moving down, we have all the disclosures and representations by the seller in one section. These, some of these, especially this ABC, some of this stuff used to be kind of scattered throughout the old form. We're collecting them all in one spot. All right, and then you go through. There's a lot of these, and I'm not going to cover them all in detail. This is something that probably you guys take quite a bit of time as you go through this form with your client. Something that probably takes quite a bit of time for you to go through. Hopefully, there's been certain parts of this that are made easier to follow and look at. For example, this part right here in P with the existing loans. That section in the old form was very hard to go through and had a lot of rules. So here you can see the current lien section took up most of the well, probably about half a page there. So hopefully this will make it a little bit easier to go through this and have a discussion with your client that's focused more on what leads are out there. But make sure you don't skimp on that one, because you don't want any surprises at closing, obviously. All right, moving on down. Let's see. Yeah, so we got seller duties here. Then we got surveillance, and then firm authorization as far as photographs and video. I'm not going to go into detail on that. A lot of that is similar to the old form. The seller duty here, this is, I don't really want to skip by this, because this used to be, in the old form, buried somewhere. Honestly, I don't remember where it was. But honestly, to me, when listing agents call the hotline and they're having an issue with the seller, this is the number one thing. your seller client is required to cooperate with you. And if they're not, then they're potentially a material breach of the listing agreement, which is going to trigger your ability to potentially get a commission. I think it's one of the most important things that agents don't focus on if they're having a dispute with their client. Your client has to cooperate with you. If they're being unreasonable, then they definitely are. So this is hopefully, by making this smaller and a little bit more set out, it'll draw agents' attention to it a little bit more. Hopefully, your client will give it a little bit more credence because it is an important thing. And the details of it are just not like, you could go into all the details in the universe, but this is really the key operative word here. Your client has to cooperate with you, and if they're not, then I think that potentially opens your ability to have a broader discussion with your client about, listen, you hired me to sell your property. Let's focus on that, okay? All right. So here we have other professional advice, inspection costs, confidentiality, wire fraud warning. These are all things from the old form. You can attach additional terms. Since this is an agency agreement, there is no, you can draft whatever you want, attach whatever you want. There's no unauthorized practice of law because your firm is a, this was from a project at school. I was painting my daughter's castle, sorry. I didn't notice that. Anyway, it's not unauthorized practice of law when your firm is a party to the agreement. Just make sure that, if you have a BIC, that you run any sort of custom attachments or anything past them. You don't want to exceed your authority as an agent working for your firm. So just make sure that you got that, okay? All right, here we have a paragraph that's, it's lawyer jargon, but hopefully not too hard to read. The biggest one here is that we got some language here now where if you're going to terminate this, then you can do it by a written document between the parties, which, as I mentioned, be Form 720. Here, there's a little language added in to make it clear that if there's a termination, then you may request and require reimbursement of fees, costs, and expenses, and you might have other remedies. So, if it's a situation like that, you need that kind of reminder to your client, hey, we've put ourselves out there, done our best job to try and sell your property. You're not cooperating with us or whatever. You can show them that. Hopefully that'll help them realize what they need to do. And here we got the signature line, and that's it. We're down to page 7, and in the old form we'd have 6 more pages to go, but we don't now. All right, so that is the new form 101. In the video with the exclusive buyer agency agreement last October, I went through a lot more back and forth of differences between, or just showing you where something was in the old form compared to the new form. I'm going to skip that this time. That might be something I'll come back and revisit later. But what I will tell you is that the goal of this rewrite was to preserve substantially everything that was important in the old form and incorporate it into the new form. Of course, I'm sure Forms Committee for the remainder of this cycle will take a look at this particular version, see if it needs to be updated, maybe make some more edits, which obviously they've done for the exclusive buyer agency agreement and the property showing agreement, which we'll get into next. But they'll be looking at that and maybe make some more edits for July. But otherwise, this is going to be all these changes will be implemented on a 30-day grace period, and after that, everybody needs to be on the new form. All right. So let's go to the exclusive buyer agency agreement, and there's a couple of changes that we're going to talk about, and they're going to be highlighted in yellow. So it's just this here in paragraph 5, and then down here, which we've already covered, is the new dual agency section. So obviously I'm not going to spend a lot of time on this, but I'll spend a little bit of time on this. So it used to be some other language. This is the new exclusive buyer agency agreement, Form 201, the one that just came out in October. So these changes are to the new form. You may have seen some reports online about amending buyer agency agreements and things of that nature. And there used to be a blurb in here about amending a buyer agency agreement. And what I could tell you is that NAR has guidance on amending a buyer agency agreement. Okay, and basically, the to put the position simply would be that you can amend a buyer agency agreement as long as it's in compliance with the settlement. But what I can tell you, and part of the reason for this change, is that the lawyers in the Missouri case have come out and put in a brief, a bench brief in the court down there in Missouri, that as far as they are concerned, if you have a buyer agency agreement and then you try to amend it to because the seller is offering more compensation or there's a builder bonus or something like that, their position is that that would violate the settlement if you amend your buyer agency agreement for that additional compensation. Now, for me, and as far as the forms are concerned, this is a debate that's going to go back and forth, and there's not clarity on it right now. And because there's not, then I think that simplifying the form makes sense. Simplifying the form to simply reflect exactly what the settlement says. And I think it's something that you're going to have to pay attention to as you go forward. What I would say in the interim is make sure, and we've been stressing this from the very beginning of the settlement and these changes and everything that's been going on in the MLS, and that is simply this. And I've been having this phone call pretty regularly on the hotline, which is if you are an agent and you're filling out a buyer agency agreement with your buyer, then you have to value your services. You are agreeing to work for a specific amount. This has been required in the license law. It is now required in the MLS rules. It has always been the case that you would have a specific amount that you are working for. So value your services accordingly. And just because there's more money offered does not mean that that's something that you can or should do. And even in the part of the language that's being replaced here, there was a clear direction to the consumer that they don't have to agree, to any sort of additional compensation, even if it's suggested by a buyer agent. I guess what I'm really getting at here is that I still am getting too many phone calls on the hotline from buyer agents who want to just have their compensation float to whatever a seller or listing firm would say. And to me, it is clear that both from NAR and from the lawyers on the other side, it's been clear under the settlement the entire time that that's not permitted. It's not. And so if that's what you are doing, then there is significant risk with that as far as whether you are potentially violating the settlement or not. Violating the settlement is not just some sort of small thing. There's actually a Q&A from NC Realtors on this. The settlement essentially absolved agents from potential liability having to do with the things that were in that lawsuit. And so to take advantage of that, you have to comply with the settlement terms. And if you don't, then you could potentially be exposed again to that same risk that was presented before in that was the subject of that Missouri lawsuit. So what I would say is this, is make sure, as a buyer agent, fill out this buyer agency agreement and know your market. Make sure that if you know a particular builder is offering a bonus or something else, that you go ahead and make sure that is part of your buyer agency agreement. Make it there from the beginning. So if you are filling out this section here, you're going to put in whatever you're getting paid. In this other line here, if you know a particular builder is offering a certain bonus, you can put that in there, even if they're not looking at it right now. I would have a list of builders who are offering certain bonuses in your area and put them all, or attach an addendum if you need to. Make sure it's clear with your buyer from the beginning. But no, the particular back and forth that caused this edit, sure, there's some debate about that. But what there's not debate about is that you can't, as a buyer agent, just have your compensation float and be dependent on whatever the seller or a listing firm is offering. That's never been the case. So if that's what you're doing, it's time to switch, and it's time to think differently about how you value your services as a buyer agent. And I went, I've had a couple phone calls on the hotline where I guess I would just stress this. The buyer is the one bringing the money to closing. Like, they're the ones that bring, the particular compensation is going to be split in a certain way. But they're the ones bringing the money to the closing. So that is something to keep in mind. It's not some kind of out there where the seller is, bringing some sort of extra money. At least that's not usually the case. It's almost always going to be operate as some kind of credit to the money the buyer's bringing. And you have to think about it that way as a buyer agent. So whether it's some kind of seller credit or something like that in the contract, just make sure that you understand that the source of the money is going to be the buyer. The buyer's the one bringing the money to closing, right? They're the ones buying the property. So anyway, a little bit of an aside, but hopefully that helps you think a little bit about this sort of language. Okay. All right. So then down here, so that's where that change is coming from. Here we got the new dual agency section. As you can see, it operates the same as the listing agreement, and so hopefully that makes that section a little bit easier to fill out. All right, moving on. We got the property showing agreement, otherwise touring agreement. The edit in the first paragraph really sort of piggybacks on what I just talked about. Another aspect of what the lawyers that brought the case in Missouri, another thing they brought up in that brief that I mentioned, is that they don't believe that you could do a property showing agreement and then turn around and have a different compensation for an exclusive buyer agency agreement, which I don't want to get into the back and forth on that, mostly because part of the settlement also says that, there's as far as what kind of agency you have to have, NAR has been clear that they're not dictating that. So you can have limited agency, provide limited services, do non-exclusive or exclusive. These are all things that are already out there with existing guidance from NAR. And so trying to piece together these things that don't seem to be in harmony right now, hopefully this is a good alternative. And we'll see, what the response is to something like this. But here in the first paragraph, down below in paragraph 4, you have fee for showing services, right? Because this agreement is for showing services, and that's all, right? You're not going to make an offer with this. It's just a limited agency agreement, so you can go see properties with a buyer that you're working with, right? As a reminder, if you're a listing agent or a seller sub-agent, you don't need a written agreement with the buyer, okay? Not required. It's only required if you are working with the buyer and giving them services as their agent. Then you need a written buyer agreement, all right? In any event. So you have your fee for showing services in paragraph 4. But in paragraph 1, it talks about how you're providing the showing services. And then if you're going to make an offer later, then it may well be that you'll need a different kind of agency agreement. And that is true because you don't have a scope of authority to make an offer with this. But putting a line here saying, all right, this is what we expect to be paid if we end up signing an exclusive agency agreement later to make an offer. All right. Hopefully that it bridges the gap between these two arguments to make it clear that, hey, there's going to be different compensation if it's something else. And again, I would not skimp on this section. I would not just be at all lackadaisical about how you fill it out. Fill it out with detail. Attach something additional if you need to, but make sure it is clear that if you make an offer with your buyer, that this is what you expect to be paid as part of an exclusive buyer agency agreement, and make sure it's accurate. Okay. I'm not saying you're necessarily bound forever and ever amen to something that you put in this line. However, I do think as far as settlement compliance goes, I think it's the best that whatever you put in this line that you do follow in your exclusive buyer agency agreement later if the buyer chooses to enter into one. So just be aware of that and make sure that you're thinking carefully about how you value your services as a buyer agent with a potential buyer, or with your buyer if you end up signing this thing with your buyer client. All right. So then we have here adding language about the settlement, the fee for showing services, and then finally we have a very simple dual agency paragraph added to this just to make sure that it's clear that this may come up as even part of showing services. We still kept it on one page, so that's good news, but just making sure that the client knows that that's potential and make sure the WWREA reflects that. All right. And then finally, we got a new non-exclusive buyer agency agreement. You can see it's 3 pages. I can't remember how many pages the old one was. I don't think it was super long, but in any event, it is shorter, and it definitely reflects not only the changes that we're going through now, it sort of tracks with the way these new agency agreements flow. So I'm not going to spend a lot of time on this. I am going to highlight one big things. So here, you have same couple top paragraphs as the exclusive buyer agency agreement. You have a term. And then here you have a fee for services. Now, you used to specify a fee in the old non-exclusive buyer agency agreement, so that's not new. However, what is new is in 4A here, is the buyer will or will not be responsible for paying the firm's fee. Old Form 203 used to provide automatic default language that the buyer was not obligated to pay anything, okay? Here, it is negotiable, and if the buyer will, then they understand that they're going to have to pay. And then you have fee earned due and payable. That stuff is normal. Again, you have dual agency here. You can see the dual agency section is the same as what we've already covered a couple times today. And then otherwise, you've got substantially the same kind of language to fill out the rest as the exclusive buyer agency agreement, and then signature lines. So there you go. All right. That's all the forms changes that we got for this. I do not expect any further forms changes before July. And so hopefully, we'll see what kind of forms changes come out in July, but it'll be something that hopefully we'll get in some good things that, for example, we are currently working on guidelines, like official guidelines to the exclusive listing agreement and to the buyer agency agreement, and also the new construction contract. So we're working on those. Whether they will be done by July 1st, we will see. We're also working on a couple other things as well. In any event, it's been a very busy cycle. Again, thank you very much to the Forms Committee for their work on this, and for the Joint Forms Task Force, and for Executive Committee for looking at all this stuff and helping you guys, go out there and navigate this environment the best way that you can. As always, if you have any questions, feel free to reach out to the legal hotline. The email for that is legalhotline@ncrealtors.org. And the phone number is 336-294-1415. Please do not give that phone number to your clients. They never if you give that to your clients, they never like it when I explain to them that the legal hotline is only for Realtor members. So please make sure that you are not giving that to your clients. And but feel free to reach out to us if you have any questions on any of these forms or anything else going on. All right, till next time, take care.